Mr. Gill, good morning to you.
Good morning, Your Honors. May it please the Court, William Gill from the Appellate Division of the Public Defender's Office. I'm here this morning on behalf of Mr. Randall Neece. With the Court's permission, I would like to reserve 4 minutes for my rebuttal.
Very well, thank you.
The sole issue in this appeal pertains to speech, specifically the speech of the trial court and the impact of that speech on Mr. Neece's right to a trial before an impartial tribunal and an impartial jury. What we know from U.S. Supreme Court case law is that a court's monuments and symbols are a form of speech. If we look around the courthouse where we find ourselves today, we see many examples of this. On the ceiling right above my head, there is a depiction of Lady Justice. She is carrying the scales of justice. On the vaults of the ceiling around the edges, we also see depictions of the scales of justice. And of course, behind Your Honors is the seal of the judiciary, which again depicts Lady Justice blindfolded, carrying the scales, and contains the motto of the judiciary, a Latin phrase which translates to, may justice be done even if the heavens may fall. There is, I would suggest, a unifying theme to all of these symbols, and that is impartiality. The blindfold suggests that Lady Justice is blind when she administers justice. The scales suggest an objective weighing of the facts and the law.
What if the Lady Justice above you, though, Mr. Gill, is not blindfolded?
No, and I looked into that some, Your Honor, because I was a bit confused about that, and in fact, there is
one of the fun trivia parts about this.
There is an explanation, which is that her apparently, I'm citing Wikipedia here, so forgive me. Apparently, her maidenly appearance and demeanor suggested impartiality, such that the blindfold was considered redundant by some artists, and they preferred to depict her seeing all before her.
Yeah, I heard, it may have been from Judge Hickson's longtime law clerk, that maybe she was looking at the mountains, maybe.
I've heard the same story, okay. a bit of legend.
Well, how about this? So the monument that's at issue here, I see from the record maybe writing on one side of the monument. Is there writing on the side that's facing the sidewalk?
That is not apparent from the record, Your Honor.
Are there other monuments at the courthouse? So, for example, is there a monument commemorating a sesquicentennial celebration or something like that?
To my knowledge, the only evidence in the record is of the monument that is the subject.
Okay, so this is the only monument. Okay.
I'm not saying as a matter of fact, in fact, Your Honors, I've never been to this courthouse. I'm not saying as a matter of fact that if you go to this courthouse, you will not see other monuments. But in this record, in the images that are depicted in the record, which I have included in my brief, the only monument that is depicted is the monument to the Sullivan County victims of violent crime. And it was stated by trial counsel for Mr. Neece that there were no monuments to exonerated defendants or anything of that nature. And that was not disputed by the state when this motion was argued. And so as we were discussing, the monument in this case, in contrast to the monuments that we have in this courtroom, the monument to the victims of violent crime in Sullivan County did not impart or reinforce the principle of impartiality. To the contrary, it demonstrated the court's partiality to a particular stakeholder, that is, the victims of violent crime, and that partiality extended to Ms. Lakeisha Neece, who it was undisputed was a victim of violent crime in this case. In fact, she was referred to as the victim by the state and by the trial court throughout the trial. And of course, Mr. Neece did not dispute that he was responsible for her killing, and so it was undisputed that she was a victim. The only factual dispute in this case was his state of mind or level of intent at the time of the killing. And so
Can I ask you about, you're talking about this as speech by the trial court. This particular victim name was not on that monument, and nothing was about this particular defendant. And the trial court told the jury a couple times, anything that I say should not be used to show any type of impartiality. I think the direct quote was, you must not concern yourself with these rulings, nor by any such ruling, these instructions, nor by any other remark that I have made do I mean to indicate any opinion as to the facts or as to what your verdict should be. Doesn't that direct instruction from the court trump any implied impartiality toward a victim?
First of all, I do acknowledge that in the sort of boilerplate instructions, the trial court did say the things that you quoted. I would suggest that it does not trump. In a best case scenario, it would create a situation of mixed messaging. And if we look to past cases, such as Walsh versus State from the Tennessee Supreme Court, you had the same scenario, where the trial court's general instructions included these types of admonitions that you should decide the case based upon the facts and the law, but then there was some message that the jurors perceived to be emanating from the court that contradicted those instructions, and in that case, the Tennessee Supreme Court held that there was an improper influence and that a new trial was appropriate. And so, respectfully, Your Honor, I would contend that the same is true here, where the sort of generic instructions that the trial court provided were not sufficient to override the message of partiality that was conveyed to the jurors by this monument.
Is there any indication in the record that any of the jurors saw this monument or took notice of it walking into the courthouse?
There is, we would contend that there is, Your Honor. And so this goes to the question of exposure. It is Mr. Neece's burden in bringing this constitutional claim to demonstrate that at least one juror was exposed to the message. And when this motion was argued, counsel for Mr. Neece submitted proof that this was a large three-stone monument right outside the courthouse door, and that anyone walking in or out of the courthouse would be exposed to the monument. And
Coming from a particular direction, though, right? So if you came from the other photograph, it looks like in the pictures, you would not have walked by the monument. Is that correct?
it's really hard to tell from the photographs exactly where the door is located with respect to the monument, which is why I think it is critical that the trial counsel submitted an affidavit indicating that walking from the parking lot to the courthouse, entering or exiting the courthouse, one would be exposed to this monument.
But I think from the pictures, it looks like, are there two parking lots? There's a main, my recollection is that if I'm facing the monument with the courthouse in the back, so I think there's a circle path in front of the monument. There's a parking lot off to the right that you would have to pass by the monument to get into the door. But there's also, it looks like a main parking lot over to the left. And so if I came in from that way, I wouldn't pass in front of the monument.
I believe there were two parking lots, and there was some discussion about which parking lot the jurors would have used. And it was not entirely clear which of the parking lots that you're referring to that the jurors would have parked in. I believe they were instructed to park in a particular parking lot.
But back to Judge Hickson's question, do we have to make assumptions here?
Again, that's why it's critical that there was proof by trial counsel, an assertion backed up by proof, stating that anyone walking into the courthouse would be exposed to this monument. And here's what is critical. The state agreed. The state, on the record, agreed and conceded that this monument was something that any person who walks into the courthouse would see. That was specifically stated on the record, page 10, volume 2, by counsel for the state. And so as far as we are concerned, that resolves this matter.
That's assuming that they looked up at it instead of looking at, oh, what room am I supposed to go to on a sheet of paper? Like there was, as I recall from the record, there's nothing in there where any juror, and I don't know if it would have been appropriate anyway, said that, oh yeah, I saw that.
It is correct, Your Honor, that there is no testimony from any juror in the record. We would contend that when the standard is exposure, when Mr. Neece is tasked with showing, as part of his burden, he's tasked with showing exposure, that it is sufficient that we have a large monument that everybody agrees is plainly within the line of sight of the jurors, and that they were exposed to it every time they walked in whichever direction, in or out the courthouse, where they would see that message. Now, the state...
But once again, though, Mr. Gill, I mean, if the state, I guess on the motion for new trial, conceded they would have to walk by it, that's not the same as exposure, though, is it? So, for example, a juror walking by the monument not only has to take notice of the fact of the monument, but I think for the claim to prevail, the juror also has to be aware of the message that's being communicated by the monument, and then therefore maybe attribute that message to the court, as you were saying. if the record doesn't show what message or what writing was on the back of the monument so that someone passing by could see it, it's hard to believe that the record itself establishes exposure, particularly when the jurors are asked about it in voir dire, and no one apparently indicated that they were either aware of the monument or aware of any message contained on the monument. So it looks like we have affirmative proof in the record that no juror was exposed, at least at the beginning of trial, and that the claim here rests upon speculation that a juror walking by it would have taken notice, would have understood a message being communicated with it. So what's the best response to that?
A couple of points in response to that, Your Honor. Number one, we would contend that the plain meaning of exposure is satisfied when a monument with large font in English is directly in the field of vision of someone walking past it.
And maybe I push back on that a little bit. How would someone on the sidewalk side of the monument see the writing that's on the opposite side?
Well, on that point, Your Honor, when it comes to the specific logistics, we would just turn back to the concession and agreement by counsel for the state that this is something that someone would be walking past, and whether it's walking one direction entering the courthouse or the other direction exiting it, that they would have a chance to be exposed to the...
Would you agree that someone walking by would have to understand the message being communicated?
And it's our position, Your Honor, that the message is crystal clear based upon the fact that this is a monument representing court speech and showing the court's dedication to, quote, Sullivan County victims of violent crime.
But do you agree that, though, someone walking by would have to understand the message being communicated?
I would agree that the message must be apparent enough that someone walking by and seeing it would have to understand that it conveys the court's partiality, and we contend that it does.
Okay,
So for example, if it were in Chinese characters and there was no evidence that anyone on the jury spoke Chinese, I think that would be a problem for us.
So is there any evidence, maybe apart from speculation, maybe is there any evidence that any juror walked around the front of the monument to read what was on the monument there?
There's no evidence about the jurors' specific path that they would take from the parking lot.
And that matters,
to the
doesn't it?
courthouse.
Since the record doesn't show that there's any writing on the back side of the monument where the prospective jurors, the actual jurors, would have passed by. That matters, doesn't it?
But I would say, Your Honor, because of the path from the parking lot was a little bit uncertain, that it's possible that they would have to walk past the portion of the monument where the lettering is facing, depending upon the route from the parking lot. Again, I think it would be unfair to Mr. Neece to say that the state conceded that this was something that somebody would see every time.
It wouldn't be unfair. He had the opportunity to put on the proof on the motion for new trial, right?
However, once the state conceded it and agreed to it, that resolved the matter.
I don't understand the concession. Can you help me with that?
A concession to a factual matter that this monument and its message are something that everybody would see as they walked past when they were walking in the
See,
court.
I thought the state was saying this is something that everyone will be walking by. They may notice it. They may not notice it. That doesn't sound like a concession to me, that there's exposure.
I do think they stopped short of conceding that everybody would notice it, and of course it's possible.
Okay, then there's not much of a concession there, then, Mr.
Well, it's possible that somebody could walk past something and not notice it. Any of us, perhaps somebody did not know before we talked earlier that the Lady Justice is not blindfolded. People have been in this courtroom and they might not have noticed.
Once you concede that it's possible, have you given up the ghost?
No, Your
Because
Honor.
at that point, we have to rely upon what's in the record. And if we're conceding that it's at least possible that people wouldn't notice, don't we have to have proof in the record that someone did?
But there's one more point in the record, Your Honor, which is that the prosecutor pointed out the monument to the jurors during voir dire. So anyone in this courtroom who was not aware of Lady Justice being unblindfolded at the beginning of this argument is now aware because we pointed it out to everyone in this courthouse earlier.
But in voir dire, though, the prosecutor didn't indicate that it was a monument to the victims of violent crime. The prosecutor only noted, did anyone note the monument outside?
That is correct, Your Honor. The prosecutor did ask the jurors if anybody had seen a monument and then asked a few other questions about whether they parked their cars and walked in and so forth. I would note that the prosecutor then remarked that she did not see heads moving either. She did not see heads moving, I believe, was the remark, which we would interpret as not receiving a response either way from the jurors about the monument. That occurred during a series of multiple questions that really did not solicit any response either way from the jurors. Moving on, if I may, from the point of exposure, I did want to have an opportunity to address a threshold issue in this case, which was the state's claim that Mr. Neece has waived his constitutional claim by failing to present it to the trial court. I would note that Mr. Neece filed his motion for change of venue due to prejudicial monument installed in front of courthouse. That was the title of the motion. He filed it on the first day of trial, immediately after the monument was unveiled the day before the trial. He cited all of the relevant constitutional provisions. He cited multiple cases, published cases from Tennessee, explaining the principles that govern his constitutional claim. The motion was argued. He received a ruling from the trial court. He reasserted the same claim in his motion for a new trial, again, obtained a ruling from the trial court. And so he did everything that was required to preserve this issue for appeal. The state does assert that he did not present his claim to the trial court. I think that claim by the state is plainly contradicted by the record. The state also claims that waiver occurred because he somehow shifted his argument. Again, I don't think the record bears that out. He is asserting the same claim on appeal by contending that this court should send this case back for a new trial before a court that does not have compromised impartiality and before a jury whose impartiality is likewise not compromised. That's the relief we would request. Thank you, Your Honor.
All right, Mr. Gill, thank you. General, good morning to you.
Good morning, Your Honors. May it please the court. Garrett Ward on behalf of the state of Tennessee in the matter of State versus Randall Neece. Your Honors, this court must affirm Mr. Neece's, and uphold Mr. Neece's conviction for first-degree premeditated murder because the sole claim he's raising on appeal that this victim's monument on the grounds of the Sullivan County Justice Center constituted an improper influence or improper information on the jury is both waived and meritless. I'll begin my time, I think, by briefly addressing the state's waiver position, just to make it clear to the court what the state thinks the basis of waiver is, and then I'll move quickly into the merits, because ultimately I think given what we have in this case and the lack of evidence, this court's analysis isn't moved all that much. But on waiver, as my friend on the other side just mentioned to the court, at a pre-trial stage before a jury is impaneled, Mr. Neece filed a motion seeking a change of venue because of the existence of this monument. There was a brief hearing where no real proof was presented. There's an affidavit attached to the motion, and I believe some news articles with photos, but no additional proof is received at this pretrial hearing.
I mean, the dedication of the monument was the night before trial, right?
That's one of the articles indicates that, yes, Your Honor. There's certainly no indication that any of the veneer members were at the dedication or read any of these articles. That's not in the record, but the dedication was either the night before or the weekend before, I forget specifically. But so that's what we have pre-trial is this venue change motion, which does allude to various constitutional provisions from the Tennessee state and federal constitutions, but it is primarily in the context of seeking a change of venue. And then at the motion for new trial, in the first amended motion for new trial, and then the second amended motion for new trial. So Mr. Neece presented this claim 3 times to the trial court. To the trial court and indeed to the state, what he uniformly said is the trial court erred in denying my motion for change of venue due to the victim's, I believe he's a prejudicial victim's monument on the courthouse. That's what he says all 3 times. And then at the motion for new trial hearing, there is no proof. Indeed, there's no argument really on this issue at the motion for new trial hearing. Mr. Neece's counsel just stands on the 2-sentence argument on the issue he presented in his 3 various motions for new trial. And the state's position here, Your Honors, is that when Mr. Neece repeatedly presents a venue change claim in his motions for new trials, and I think that's the only way to interpret what he's presented, that's the claim he's preserved, and that he hasn't preserved this admittedly related claim, but legally distinct. As I'll discuss with the court later, there are pretty different legal rubrics that apply to allegations that a trial court erred in denying a venue change and these improper information or influence claims. They're legally distinct claims, although they seek to safeguard many of the same rights, admittedly.
And have the same remedies.
Can have, yeah, at the point, yes, at that point, they do have the same remedies. Pre-trial, you know, the venue change is different, but in the motion for new trial stage, we are seeking the same remedy, yes, Your Honor. But ultimately, if Mr. Neece wanted to present and preserve this improper influence or information claim on appeal, then he should have raised it in his motion for new trial, and he didn't. He very specifically raised this different venue change claim.
Well, he could not have raised an exposure claim that the jury was improperly exposed to extraneous information. He could not have raised that pretrial.
I agree, Your Honor.
Just as a motion to change a venue would not preserve a claim of improper exposure to extraneous information.
Your Honor, I agree entirely, because sort of endemic in the improper information or influence claim is that a jury exists. And there isn't a jury at the time he makes this venue change motion.
So when is the proper time to raise then the question of the improper exposure to extraneous information?
Either sometime at trial, in one of the, I believe it's the Gilbert case from this court. I get the two cases related to the Giles County Courthouse mixed up sometimes. In the one that is citable, a panel of this court indicated that parties should raise it at trial when they're aware of the influence, but if this court thinks that that's maybe too harsh of a line to draw, then certainly at the motion for new trial. But I think the important thing for the purposes of this case is he needs to raise it at some point before appeal, whether that's during trial or in sort of a promptly timely filed motion for new trial. He needed to raise this improper influence or information claim, and he did not. And because he failed to do so, it is waived. And I think that waiver is interesting in this case because although the two claims, venue change and improper influence or information, although they're related, there's some pretty important legal differences specifically when it comes to burdens. In a venue change claim, a defendant, to show that a venue change motion was improperly denied, a defendant has the affirmative burden of showing that an actually biased juror was seated on his jury. And this makes sense because sort of the nature of the venue change claim is the assertion that it's not possible for me to get a fair jury. So when you say the trial court erred by denying it, you need to come forward with the proof saying that your assertion was correct. By contrast, the improper influence or information claim that the defendant now presents on appeal has a shifting burden framework. There is an initial exposure burden that is on the defendant, and I'll discuss with the court why I think that burden isn't even met in this case in a moment. But once that sort of lower burden, exposure is certainly a lower burden than an actually biased juror being seated on your jury. Once that burden is met, the burden shifts to the state to show that the exposure was harmless. And I think what happened in this case is that the motion for new trial, no proof was introduced. No jurors were called, no courtroom officers were called, nobody was called to testify whether anyone knew anything about this monument. And generally, Your Honors, when evidentiary hearings produce essentially a null set of evidentiary value, the party with the burden loses.
I mean, the rules of evidence would have allowed the defendant to call a juror for the sole purpose of asking whether the extraneous information was before them. Is that right? But you can't ask about how it influenced the jury's deliberation.
That's my understanding, Your Honor. I believe it's Rule 606B, I believe is the subsection, would allow for a juror to be called to ask, did you see this monument? Did you understand what it was about?
So as I understand your friend on the other side, my belief is, and he'll correct me in just a moment, my belief is that the argument is that the defendant met the burden, if we're talking about an exposure claim, met the burden by two things. One, the state put the whole jury on notice that there was a monument out there, and it's reasonable to presume that the jurors would be curious about it and perhaps would investigate it. And two, that jurors passed by the monument. My understanding is maybe it was a one-day trial or a couple of days, 3-day trial, that they would pass by the monument on their way into the courthouse. And once again, it's reasonable to assume or to expect that the jurors would have been aware of the monument. And that 3, there is a purported concession by the state that the jurors would walk by the monument. I don't know if the concession goes any further than that as it goes. Why is that not enough for that to move then to the shifting, to shift the burden back to the state?
3 points on that, Your Honor. First, I'll sort of go in reverse order from Your Honor's question. Regarding the concession, I don't think the concession goes much farther than if you park in this parking lot, you'll walk by this monument. It certainly stops short of saying like you will necessarily see the monument. Regrettably or not, this court is almost certainly aware many people walk from a parking lot to the entry of a building with their heads entirely in their cell phones, not taking notice of anything around them. So maybe not even seeing the monument, certainly not seeing, this is etching on granite. This is not some neon billboard. It's three sort of nondescript granite pillars with writing etched onto them. So I think the state's concession doesn't go much farther than jurors that park in this certain parking lot will walk by it. My second point is it's certainly not established in the record that every juror would have to park in that parking lot and walk by that monument. The record is a little unclear on what the status of parking at the Justice Center was at the time of trial. I think either on the affidavit or on the motion, there appears to have been an assertion initially typed that that was the only parking lot available, and then that's been scratched through, I take it, by either the affiant or the filer of the motion. So perhaps there was some level of construction. It's not really clear, but to the extent there's a lack of clarity in the record on would people necessarily have to walk by it, that would...
Well, you only need one juror, though, to be exposed to extraneous information, right?
Right, and Your Honor, that brings me to directly to my third point. As is often the case, you're one step ahead of me. It brings me directly to my third point, which is all you need is one juror. A really great way to get that one juror would have been to ask any question or call any witnesses at the motion for new trial hearing. Where this issue, or we're not really presenting the information or exposure claim at the motion for new trial hearing, it's the venue change claim. But regardless, I think my point stands that the defendant was well equipped to get his one juror, and he completely failed to do so. The record is, at best, for the defendant, utterly silent on whether any juror, A, saw this, or B, took any notice of what it meant. Maybe not to tell on myself as a bad citizen of the state of Tennessee, but I think just about every day I walk past some historical monument, plaque, statue, and don't pay much attention to what it's saying or the message it's holding out. And the same is well possibly true of these jurors here. And the point is, for the defendant to prevail on this claim, he needed to come forward with evidence suggesting that somebody saw this and understood what it meant. I believe my friend on the other side conceded that they needed that for him to prevail on this claim, whether on plenary or plain error review, he needs to show that a juror both saw the monument and understood its message. And as I said, the record at best for him is silent on that. And frankly, in the state's view, it's rather harsher for him than that, because there is a single question asked not by the defendant, but by the state. Did anybody notice this monument? And there's no affirmative response. I take it jurors were either shaking or the veneer was either shaking or nodding heads primarily that morning, or weren't particularly talkative. But the prosecutor says something along the lines of, I'm not seeing any moving heads or nodding, something like that. So there's no response. So I'd suggest that the best read of the record is that nobody has, when they're asked, nobody says they've seen it.
If we're talking about an exposure claim, though, is that fair? Because you and I think, just agreed that you could not raise an exposure claim prior to the jury being sworn. And so could we use responses by the venire in voir dire as evidence that there hasn't been later exposure?
I think in the ideal...
That's not fair, is it?
I think in the ideal case, Your Honor, we probably wouldn't be talking about it. The only reason I'm talking about it,
Sure.
it is quite literally the only scrap of evidence we have about anybody that's ultimately on the jury seeing this monument. Ideally, a similar question would have been asked of a specific juror, maybe all 12 jurors at the motion for new trial hearing, but none of them were called by the defendant. So while I agree that the exposure claim likely could not have been presented in a pretrial posture, I think that the questioning during voir dire does sort of provide some sort of evidentiary base layer for what do the people who will ultimately make up the jury, what have they seen? I mean, since the defendant's claim is dependent on jurors seeing and understanding this monument. I think it's relevant, even if perhaps not ideal. So, Your Honors, I think the defendant, under any standard of review, has failed to meet that exposure burden. And I'd like to turn, I guess, to even if this court thinks that, perhaps through some amalgamation of probabilities, which again the state thinks is insufficient, but perhaps through some amalgamation of probabilities, walking by it, maybe a juror did see it and understood it, so this court thinks or comes to the conclusion that the exposure burden was satisfied here. The state has absolutely met its burden given the quantum of evidence in this case that exposure would be harmless. Your Honors, without being hyperbolic, I think I can faithfully say to this court, I'm not certain I've ever seen stronger evidence of guilt of premeditated murder than was present in this case. And I'll briefly run through not the entirety of the state's case in chief, but just the highlights. The defendant gives a full confession after the killing to killing his estranged wife, Keisha. And interestingly, when he talks about murdering his wife, he says that he killed her because that's what she wanted, because she wanted to die. So I think reading that confession, the defendant is there saying, yeah, I intended to kill her. I did it because she wanted me to, but I intended to kill her. That alone would be really great evidence of premeditation, but there's a great deal more here. There's the defendant's comments to his girlfriend the morning of the murder, something along the lines of, this is the last time you're ever going to see me. My wife was way worse than I thought. She will never hurt somebody the way she's hurt me. Right before the murder is committed, the defendant takes steps to conceal the fact that the murder is occurring from his and the victim's daughter. He sort of sequesters her in her room, turns the television up high so that she's unable to hear him strangling her mother to death in the room next door. All of that, Your Honors, would be among the strongest evidence of premeditation I've ever seen, but it really pales.
Didn't he also record himself as saying something like he was glad that she was dead even before she may have actually died?
Judge Greenholz, you're one step ahead of me just again.
Go ahead. All right.
Yeah, really, it pales in comparison to the lodestone in this case, which is Exhibit 94, this sort of Agent Cooper and Twin Peaks style pocket recorder that the defendant carries with him. He recorded himself essentially committing this murder. What this court will hear him say is, I'm glad she's gone. Again, says she'll never hurt anybody the way she hurt me. My daughter won't have this terrible mother. He then goes on to say, and I won't be going away for it because I'm going to go out with a bang. So he's sort of in this recording saying, I'm glad she's dead. Here's why I'm glad she's dead. I'm not going to get in trouble for killing her because I'm going to commit suicide. And I think most troubling with all of this, Your Honors, in the background of this recording, this court will be able to hear Keisha Neece gasping for air and crying in pain. So what we have here is quite literally a defendant talking about his gratefulness for committing a murder while we can hear the murder happening in the background. Overwhelming is an overused word when we talk about the strength of evidence in various cases, and I won't use it here because it pales in comparison to, or it falls far short of describing how strong the evidence in this case was. It was all-encompassing evidence of guilt, incontrovertible evidence that the defendant had a specific objective and that to kill his wife, that he premeditated about killing her, and that he then did it. And with this in mind, even if a juror saw this monument, which isn't proven, and even if a juror understood what it was about, which is even less proven, it simply doesn't affect what happened here because the evidence was so unbelievably powerful. Unless this court has further questions, I would ask that you affirm.
Thank you, John.
Thank you, Your Honors.
Mr. Gill, 4 minutes from rebuttal.
Thank you, Your Honors. My friend indicated a concession that I want to clarify. He said that I had conceded that Mr. Neece's burden was to show that at least one juror was exposed and understood the message. I don't think that is accurate. I think he has to show exposure. The case law says exposure. That is the standard. I do think, and we went through this with an exchange before, the message must be such that a reasonable juror would understand it. And so, like again, if it were in a different language or something. But all that is required to be shown is exposure. And based on the plain meaning, a person who it is conceded will walk past a monument is exposed to that monument. As a child, my mother was an artist, so as a child, I frequently was taken to museums and I saw art. I was exposed to art. Now, did I understand the genius of Picasso? No. But I was exposed to art. The plain meaning of exposure is certainly established here, where it's undisputed that all of these jurors were walking past this monument multiple times during this 3-day trial. Quickly on waiver, I respectfully disagree that it is impossible to bring an exposure claim before trial. The exposure has not yet occurred, so the burden at that point is a little bit trickier, and it is to show that such exposure will certainly occur. I think a more stark example would be, imagine a courthouse that has a giant banner within the courtroom that says, "In this courtroom, all defendants are presumed guilty." In that situation, you would not have to wait until the jury is impaneled to say that this courthouse is a problem. It has an unconstitutional message. We know that all the jurors are going to be exposed to that message. We need to move for a change of venue. Now, that's an extreme example, of course, but Mr. Neece did effectively the same thing here, and again, the state agreed that the exposure would occur, and so that was sufficient. And he did bring his constitutional claim in the context of a motion for a change of venue. That is perfectly permissible. Rule 21 says, it expressly states that a party may move for a change of venue based upon undue publicity, which is more typical, or for any other cause.
If the exposure claim was brought pre-trial, it necessarily fails given voir dire, right?
No, Your Honor,
I mean, because the state specifically asked whether anyone was aware of the monument, and there were no affirmative responses. And so the state clearly has met whatever burden would be there, right?
No, Your Honor, because the claim was that the jurors would be exposed not necessarily before voir dire, but throughout the trial. And so it's quite possible that they did not notice the message initially, although they didn't say either way during their responses, but that they would still be exposed to this message throughout the course of the trial, which is exactly took place. So Mr. Neece met his burden that was set, and the burden was set forth very clearly in the authorities that were cited in his motion, and the state is the one who chose not to put on any proof. The state, therefore, as soon as Mr. Neece met that very light burden that he was required to meet, it was the state's burden to show that any exposure was harmless.
How was the state, and your friend on the other side raises this point in the brief, how was the state on notice that it was required to put on proof? The claim in the motion for a new trial was that the court had improperly denied change of venue, which is a different legal box with different proof that has to be offered. How was the state on notice that it was required to rebut a exposure to extraneous information claim?
Because that claim was included in the motion for change of venue.
Just by reference to fair trial rights?
It had every single legal authority just about that we cite in our brief, all the same things. And so the state was absolutely on notice because that was the law that was cited in the motion. It's kind of like a motion, an evidentiary motion before trial. If it's a plain evidence motion, I see my time is winding down. If I can just finish my answer.
Sure.
If it's a very standard evidentiary motion, then it would be in one legal box, as you put it. But if it implicates a constitutional claim, then a different standard applies. And here, the motion for change of venue expressly contained that constitutional claim, and the law that was cited in the motion absolutely put the state on notice that it was required to meet its burden as soon as exposure to an improper influence was shown, which we contend that it was, and the state did not attempt to meet that burden.
Mr. Gill, thank you very much.
For that reason, we ask that this court reverse the trial. Thank you.
Thank you very much. To the parties, thank you very much for your presentation and your argument today. Very well done. Thank you for appearing today also, as I indicated at the beginning. All right. Will you call the next case, please?
Yes, Your Honor.